call us to order?
Yes, please.
All right. We are going to call this meeting of the Orthotic and Prosthetic Advisory Board to order at 10:01 a.m. And I'm going to ask that everybody on the board mute their mics unless you want to speak while we're in the process of the meeting. And we will start with the roll call.
Miguel Mojica,
Present.
David Arends,
Present.
Randall Duncan,
Present.
Mark Kirchner,
Present.
Eric Olson,
Present.
and Presiding Officer Catherine Mize.
I'm here.
We have a quorum.
All right, thank you very much. We will get started right away with the General Counsel training, and Stephen Leary is going to do this for us.
Good morning, advisory board members. Can you hear me?
You're faint, but yes.
Oh, okay, I apologize for that. I'll move a little closer. Stephen Leary, Assistant General Counsel. I'm here to present the open government training today. If you have trouble hearing me, just let me know. Sometimes I have problems with some technical difficulties. I'm going to go ahead and share up my screen, present a little PowerPoint, and then I'll be happy to answer any questions. And if you have any questions during the presentation, feel free to jump in as well. It's fairly informal, but I know most of you or all of you have had this presentation before, but it's a refresher training. It's a few important topics. So without further ado, go ahead and share up the screen. All right, can you see the slides?
We can.
Okay, very good. So there's three statutes we'll be talking about today that fall under the heading of open government. The Open Meetings Act, which is under Chapter 551 of the Government Code, the Administrative Procedure Act, which is under 2001 of the Government Code, and the Public Information Act, which is also referred to by its old name as the Open Records Act, which is in Chapter 552 of the Government Code. The common theme behind all three of these acts is transparency and allowing public participation in administrative government. We want to start with the Open Meetings Act, nuts and bolts. The Open Meetings Act, which we also call TOMA, Texas Open Meeting Act, it requires meetings of government bodies to be open to the public, and it requires proper notice to be published of the time, place, and subject matter of the meeting. Is to enable the public to know what the meeting is going to be about, and give them proper notice so that they can attend the meeting if they would like to do so. The provisions of the act are mandatory, and the courts have held there to be liberally construed in favor of open government. So it's a sunshine law. It's designed to preserve transparency. There's some key concepts. Is a quorum. So a quorum is the majority of the members of the advisory board or committee as fixed by statute. In order for a government body to take official action, there has to be a quorum. Now you can meet with less than a quorum, but you can't take official action with less than a quorum. So that's why we went through this with certifying a quorum before we got started today. Now, the key feature of the Open Meeting Act is a quorum cannot engage in deliberations without complying with the Open Meetings Act requirement, without posting the agenda. We don't want to talk about things that are outside the agenda because we want to give the public notice of what's going to be discussed. Deliberation is defined as a verbal or written exchange among a quorum of a government body, between a quorum of a government body and another person concerning an issue within the jurisdiction of the governmental body. Now, what constitutes a meeting under the Open Meetings Act? Well, a meeting occurs anytime a quorum engages in deliberations. And that becomes important when we talk about the walking quorum, which is the theme we're going to hit on in just a moment. And I guess the key concept here is you could inadvertently engage in a meeting, which would require you to comply with the Open Meeting Act without even thinking that you're in a meeting. You're just talking about business, exchanging emails, and so forth. You get to a situation where a quorum was involved and it was not posted as a meeting. That potentially, if you're engaging in deliberations, discussions about about things that are within the board's purview that potentially could run afoul of the Open Meeting Act. And that's the purpose of this training. So notice, there's a type of notice that has to go to the public. It gets published in the Texas Register with the Secretary of State, or gets posted with the Secretary of State's website. It also gets posted on the TDLR website. It gives information about the time, place, and subject of the meeting, and it lists the agenda, the items that are going to be talked about in the meeting. Now, there's times when board members will meet informally, not necessarily to discuss business, but you're going to meet to go to conventions, workshops, social functions, and you can do that. It's just important not to engage in deliberations with a quorum of members when you're outside of that posted meeting. So you can meet and say hello and talk about this and talk about that, but you could run afoul of the Open Meeting Act if you're actually talking about things that are going to come before the board or a business that should go before the board in the open meeting. So that's why we mentioned that. Really we just touched on those key points. The walking quorum, what this is you could start out with less than a quorum. So you could start out with a work group within the advisory board, which is intentionally designed to have fewer than a quorum so that you can engage in these kind of discussions and work out items without having to go through hosting it. But if you add additional people to the discussion, maybe it's just a couple of you talking and then one of you forwards the email to someone else, call somebody else. Even though you didn't have a quorum to start with, when you bring additional members into a discussion, you could ultimately have the result that you've engaged in a discussion with a quorum of members outside of the posted meeting. And that's where you could run afoul of the Open Meetings Act through what's known as a walking quorum. And there's an example that talks about that. About there's two members who are talking, and then someone forwards it to the next member, and now all of a sudden you have quorum, walking quorum. And that's one thing we want to caution against. And walking quorums can occur informally. They can occur through conference calls, video conferences, hallway discussions, emails, text messages. All those things are ways in which this walking quorum violation could occur that we just want to be cognizant of and watch out for. So to avoid the walking quorum, you shouldn't meet in small groups and then talk about the substantive item with people outside of that work group and draw in a quorum to the discussion. You want to save the actual deliberation where you're talking about business with a quorum for a posted meeting. And, this has happened. And there's something you want to add to the agenda. We want to make sure to add to the agenda. And if it's not in the agenda, we can add it to the agenda for the next meeting. We can assign it to a work group to work up the issue and then present it to the meeting. There are things we can do, but we gotta be careful not to engage in the walking quorum. There's an issue that's called polling, and what that is, it's engaging in a straw vote. So under the Open Meetings Act, the voting has to happen in an open session. The public has the right to know who's voting for what. Well, if you call up individual members outside of the posted meeting and start asking them, well, how would you vote on this? What would be your take on this if this were to come up for a vote? You engage in that kind of informal polling of a quorum. That's actually against the law. You can't engage in a polling of a quorum outside of the posted meeting. So that doesn't come up real often. That's something we mentioned there. So the guidelines, we want to limit the discussion to what's on the agenda. During the public comment portion of the open meeting, the public isn't bound by what's on the agenda. They can come up and say just about anything they want that's relevant to the board's business. But when we're addressing those comments from someone who comes in and comments, we want to be careful that the board's not starting to talk about something that's outside of the agenda. So if someone in the public comes in, they bring up something new that's not on the agenda, you can thank them for their comments, tell them we'll consider it, we'll post it on the future agenda, we'll do something with it. But we can't start engaging in deliberations of that item that's not on the Uh, so this is saying the same thing. Yeah. Don't want to wander off of the agenda. We don't want to go too far in responding to a comment to the extent that we're actually addressing business that's not posted. And what happens if you violate the Open Meeting Act? Well, there's some bad things that can happen. What can happen is someone who is aggrieved by the board's decision can file a lawsuit to invalidate that action, and the court can invalidate a decision that was made that there wasn't a quorum, or it was something that the board considered that wasn't properly posted. It violated the Open Meetings Act. It's rare that that happens, but it's something we don't want to happen, especially with a rulemaking or something that, years down the line, maybe somebody violates a rule that we pass, and now they're saying that rule should not have been adopted because it was improperly discussed and properly voted on. So we want to avoid that kind of procedural irregularity. There's also a potential for criminal penalties in the Open Meetings Act. That's very rare, but it is out there. That really would tend to occur in a very extreme type of situation, but it's out there. There are some misdemeanor penalties for violating Open Meetings Act. So that really concludes the Open Meetings Act. I'll talk briefly about the Administrative Procedure Act, which is also called the APA. And if you don't know me, I used to be an administrative law judge, so I'm familiar with the contested case part of the APA, which we're not talking about. There's really two sides to the APA. There's the contested case portion that deals with the rights and procedures when a case goes to a hearing. And then there's the rulemaking part of the APA, which we deal with, which deals with how a government agency adopts rules. So the purpose of the APA is to establish uniform standards for state agencies, provide public participation and transparency during the rulemaking process. Now, what is a rule? This gets a little hairy sometimes because there can be guidelines on a website, there can be instructions on a form, there can be things where the agency is telling someone to do something that actually don't rise to the level of what's considered a rule that has to go through the formal rulemaking process. And sometimes an agency can run afoul of that and start putting instructions on a form or making people go through a particular hoop when that's something that really should have gone through the formal rulemaking process. So the courts have held that a rule is a statement of general applicability by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. Now, what's not a rule? A rule excludes a statement regarding only the internal management or organization of the state agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. And what are the sources for rulemaking? These ideas for a rulemaking can come from many different places. There can be legislative changes, and the rule package I'm going to present today came about as a result of the bill implementation process and some legislative changes. A rule can also come from you as an advisory board. You can have an idea for rulemaking that starts at your level. They can come from staff. The people who work the program they might realize there's some kind of a problem, some difficulty, and suggest a rule change. There's a 4-year rule review process that we have to go through in each program under the APA to make sure the rules are still relevant and that they still serve a purpose. And that can, as part of that process, we poll the various department members and we publish the register and seek public comment. As part of all that, a lot of times ideas for rulemaking will come up. There's also a procedure for a rule petition where interested people can petition the government to require us to consider making a rule. So that doesn't come up real often, but that's there. Now, an interested person can petition the agency for a rulemaking petition. To be an interested person, you have to either be a Texas resident, a business entity located in Texas, a subdivision of the government, or a private or public organization that's located in Texas. We won't go through all the details, but this is just a broad overview of the rulemaking process. You start with an idea, and then there's a lot of internal review and analysis that goes on. I'm involved in a lot of that. Then there's a procedure to get pre-clearance from the governor's office, and that's a relatively new requirement that we have to send a memo in the rule package to the governor's office, and they have to kind of decide whether or not they're supportive of the rule. There's a lot of other steps that go in there. With the bill implementation rulemaking, we also send the rule package to the legislators, their offices that were involved in the chair of the committee in the legislature that proposed the bill. But ultimately, you have a first advisory board meeting where we discuss and hash out the rule, and then decide whether you want to proceed with publishing it in the register. And it gets published in the register. There's an opportunity for the public to comment. It's a 30-day public comment period. And then we meet again to talk about the public comments. So it's important we get the public a chance to comment, and we also want to consider their comment in some way. That's the second advisory board meeting. You can either make changes at that level, or you can go ahead and recommend it for approval by the commission. And then the commission votes on it in an open meeting. People can also come to that meeting and comment if they want. And then we have to let the public know that there's a new rule. So we publish it in the register, and the rule will say what its effective date is. The rule review process will just sort of, understand that's every 4 years, every program, there's a rule review process. There's a notice of intent to review that gets published in the Texas Register. Same situation, there's a 30-day comment period. And we get a bunch of memos. We talk to all different departments. And then the commission can do one of three things in the 4-year rule review. We can either re-adopt the rule, we can re-adopt with changes, or we can repeal the rule. Generally, we have to re-adopt the rule because if something comes in during that process and someone wants to change a rule, well, we have to let the public know what that change is going to be and give everyone a chance to comment on that before we change the rule. So what happens is the 4-year rule review is kind of a starting place, and if it becomes clear that we need to make a change to the rule, then that takes us back to the regular rulemaking process of changing the rule. But it requires us to take a hard look at the rule every 4 years, and that's really the intent of that. That's it. There are various different resources available, including a handbook from the Attorney General's office. And I'm also available to any questions about the rulemaking process. Well, now I'll go briefly into Public Information Act, which is also talked about as the Open Records Act. People still call it that, but the official title is Public Information Act. It makes documents, records, and other information relating to official business open to the public. There are a lot of exceptions to this, but the general rule is government records are open to the public. And that, you understand that includes emails. It can include things on your personal device if you're talking about government business on your personal device. So you'll be aware of that. It's best to use the government device. If you're going to use your personal device, that's fine. But just be aware that those records, they don't stop being government records if you're discussing business with your personal email. You still might have to furnish those records in response to an open record request. And again, it's designed for transparency of government. The act is construed liberally in favor of granting requests for information. There are a number of exceptions to things that we would redact or withhold in response to open records. And there's there are attorneys in our Office of General Counsel who are dedicated to responding to these requests. There are a few things about open record requests. They have to be in writing, so they can't just call and ask for information. They do have to put it in writing. There's no particular form that it has to be in. It has to go to it has to be in writing, and we have 10 business days to respond to the request. And that's a process OGC is involved in. It's important that we timely respond to it, because if we don't, we can lose the right to withhold certain records. It makes it harder for us to withhold records if we don't respond timely. We don't necessarily have to furnish the records within those 10 days, but we have to respond within that time period about whether we're going to or not, and then respond with what we do have. So the upshot of that is, if you get something that looks like a request for documents, a request for records, forward that to Office of General Counsel so they can work it up as an open record request and start working on it right away. There are certain things that are not public and that we're not going to release, but we still have to go through the process and review it. Certain types of personal information like dates of birth, driver's license numbers, certain medical information that's confidential, certain complaint information that is confidential. And there's a process for us if we want to withhold information. We sometimes have to get a ruling from the Attorney General's office. And that could come into you. I mean, we want them to come into the open records email address, but it's not unheard of that you might get a request from somebody for documents. If you do, forward it on to GC Open Records. And that's all from my presentation. Happy to answer any questions you have about those open government statutes.
I have a question for you, Stephen. Where are we on the 4-year rule review timeline for this program?
I don't know. I can find out for you on that. Steve Ucker, I think, would know. I took over this program about a year ago, and I think we had just completed the rule review about a year ago. So I think we're about 3 years till our next one. But Steve, can you confirm that?
Yeah, we did the 4-year rule review, and I think we've completed it. And I think we found things that we would like to change, but I think we did make some changes. But anyway, I believe that the 4-year rule review is complete.
Yeah, I think we got a few more years to go till we get another rule.
Okay, so then I would understand, this is Catherine Rice speaking, I would understand then that process is completed without any involvement from the advisory board.
I think generally, if the answer is going to be that we're going to re-adopt the rule, I think 4-year rule review doesn't generally involve the advisory board. But if during that process it becomes clear that we need to make changes, I think that's when we would involve the advisory board.
Catherine, I think I might be thinking about podiatry. So we would consult with you that this has been completed. The rules, like with another program, the rules were adopted, and then we created, some action items and things to bring to the advisory board. And so if you have not seen that, then we have not completed a 4-year rule review, would be my interpretation.
Okay, all right. It probably doesn't matter, but I would like to express the interest that 4-year review does include work group or members of the advisory board with their thoughts and opinions on some of the rules. I think it would be.
And just to clarify, to make changes to the rule, we don't need to wait 4 years. You can do that at any time. You want to make changes to the rule, we could do that. The 4 years is just to make sure that the agency takes a hard look at the rule and give everyone a chance, give the public a chance to comment. But the purpose of it is to make sure that the rules continue to serve a purpose under the act. So I appreciate what you're saying, and it makes sense to involve the advisory board or keep you advised of any comments that come in on that rule review. But just understand, we don't have to wait the 4 years. Anytime we want to change a rule, we can start that process.
Thank you very much. Point of order, Eric has left the screen. Are we still in quorum? Oh, he's back.
Yes, we still have a quorum. Yes, ma'am. Thank you.
Any other questions for Mr. O'Leary or Mr. It's not O'Leary, it's Leary, Mr. Leary.
Yeah.
All right, it appears we don't have any other questions, so thank you very much.
Thank you.
The next thing on our agenda is the approval of the minutes from our last meeting. So hopefully everyone has had a chance to review those that they were sent previous to this meeting for our review. So if that is the case, we would need a motion to approve the minutes.
This is Miguel Mojica, motion to approve.
All right, Mr. Mojica, motion. Do we have a second on the motion?
Arns, I'm second.
Thank you very much. And so then we would need to vote
Yes, ma'am.
and we'll do a roll call.
Miguel Mojica,
In favor, yes.
David Arends,
Aye.
Randall Duncan,
Aye.
Mark Kirchner,
Aye.
Eric Olson,
Aye.
and Presiding Officer Catherine Mize.
Aye.
Motion passes.
Thank you very much. All right, the next item on the agenda is public comment, but there were none submitted prior to the meeting, so we can move past the public comment. I do invite the public that is listening to keep track of our meetings, and if you do want to submit any comments prior to the meeting, please feel free to do that. We welcome it. The next thing that we will move to is the staff reports. Licensing division is first, and I believe Heather is going to step in for Mr. Rivas. So
I
thank you, Heather.
am. Thank you. Good morning. My name is Heather Muir, and I'm the Director of Licensing at TDLR, and I'll be giving the Licensing Division report this morning. You have all of the statistics in your folder. I would like to point out one error on the report for FY 2023 for licensed prosthetists and orthotists. You'll see where it says renewed licenses issued as 161 and online renewals as 163. Those are transposed, so flip those. You fixed my computer. You can see that we have for the first quarter, we've included FY 22, 23, and then the first quarter for 24. We are on target to, not sure what that beep was, sorry, to issue the same licenses that we've issued before. 98% renewal online for licensed prosthetists, orthotists is wonderful. 100% for prosthetists is amazing. We love to see that. 100% also online for orthotists. Y'all have 15 license types, so I'm just kind of hit the highlights instead of reading through all of them.
Heather,
Yes.
I'm sorry to interrupt. May I ask a quick question? And that is, how does the math on these charts work? The total population lines? I was trying to add things up to reach those numbers, and I'm just having a hard time reading the charts.
Okay, so what you'll see, let's look at, so on the licensed orthotist that Anna has on her screen, new licenses issued for fiscal year 22 was 6. So there were 6 of that specific license type orthotists issued in 22. In FY 23, there were 8.
Right.
Issued. For the first quarter of FY 24, there was 1 issued. And then the next line shows the number of practitioners that were renewed. Again, FY 22, 23, and 24. And then it shows you online renewal statistics, how many of those that renewed used the online system. And then it gives you a percentage of those that were renewed online out of the ones that were eligible to renew for that particular period. Then you have the total population. Those first few lines are just purely the number of new licenses that we've issued and the number that we've renewed. So as I'm sure you're aware, y'all are on a biennial renewal. So you won't see 100% of the population renewing every fiscal year. What you'll see is about half and half. And so if you kind of add FY 22 and 23 together, that would get you about 95. And then you'll see the total population is 92. That's going to give you a rough estimate if you add the 2 fiscal years together, but you always have people who roll off. Our system is a real-time system. So when we run our numbers, it tells us what that number is at that specific time. So there may be a little bit of a difference in those total population numbers versus what you might see for those first and second, for those 2 quarters that are listed. But that's the numbers that you're seeing.
All right. Thank you very much. I appreciate that.
We can keep going through, Anna, if no one has any other questions about any of the numbers on there. You have those for you that you can look at. One thing that I did notice is that we are not including on this report is the total of the facilities that are renewing online. So I would like to tell you that in FY23, we had about 92% of the facilities using that online renewal option. And we had about 90% so far in FY24. So it would be great if we could see those numbers increase a little bit, because using that online system gets the work to licensing faster than mailing in a check. So always avail yourself of that online option. If you can, I would use it, recommend that. Total individual licenses, since we don't have that on here either, is about 658. Total facility population right now is about 258 licensed facilities. So total combined, about 916 licensees for this program. Any other questions?
All right, not hearing any other questions. Thank you very much, Heather.
Thank you.
So we're ready to move on to the customer service division and Myra Rodriguez.
Hi, good morning, board members and TDLR staff. My name is Myra Rodriguez, and I am one of the managers overseeing this program for the customer service division. As you can see before you, the statistics for this current fiscal year, our total for the month of January, which is our most up-to-date information, is a total of 63 contacts, 57 of those being calls and 6 of them being emails. In comparison to the statistics for last fiscal year for this time, we are slightly lower in numbers for the statistics for this program. And overall, it seems like the trend is just that. We're just slightly lower in numbers for the month so far in this current fiscal year. And I'm available for any questions if you have any.
Hearing no questions, thank you very much, Myra.
Thank you.
Moving to our next one, it's the enforcement division, and I believe Elizabeth Wiggins will present.
Good morning, everyone. I'm Liz Wiggins, and I'm a prosecutor for the Enforcement Division. I'm going to cover a few highlights of the report for you today. First, I want to clarify the snapshot of the data we are looking at here. Sorry about that. You can see the statistics for the program are being compared for fiscal year 2023 and 2024. To be clear, this first column for 2023, that's going to include data actually from September 1st of 2022 through December 31st of 2022. And the second column for 2024 is actually data from September 1st of 2023 through December 31st of 2023. Sorry about that. At the very top, you have the division's performance measures, which are reported to the legislature. You can actually see that overall, your program cases remain a small percentage of the department's overall cases. Of the cases open for your program, 100% of those were closed in 6 months or less from the date they were opened, which is well above the 55% average for the department as a whole during that period. So this tells us that the program, your program cases specifically, moved along quickly during this period. The next section is the criminal history review for applicants. So this is actually going to be in regards to data that you're seeing here. So every new application and license renewal requires a criminal history review. So the number here is actually new applications and renewals that had a criminal history flag that needed to be reviewed by our criminal history team. So you can see that there were no cases opened in this period of fiscal year 2024. This is probably because upon review, most of these criminal history flags are things that are not directly related or relevant to your program licenses. Let's move to page 2 of the report. There you're going to find the penalties and consumer remedies section towards the end of that page. This details how many fines were assessed versus what was actually collected. So I want to bring your attention to the fiscal year 2024 column. That's where you're going to see that the department collected all of the penalties that were assessed. And now if you move to page 3, you're going to find the alleged violations at opening. These are just the reasons the case is opened on the front end. And the very next section actually details violations which resulted in disciplinary action. So those are the type of cases that we took action on. On the same page, you can find the cases we highlighted for your review. I just want to make a quick note that both of these cases resulted in agreed orders, and the respondents have paid the penalties that were assessed. Finally, on page 4, you'll see information about an initiative that the Enforcement Division has been working on as a result of the Sunset Review process, which basically puts our complaints into a prioritization level based on the risk of harm to the public. This process is intended to focus our limited resources on the complaints that have the greatest impact on public health and safety in a more efficient and effective way. And that's a wrap from the Enforcement Division. I'm available if you have any questions.
Catherine Mice here with a question. Have we been able to retain any expert, I want to say expert witness, but that's not the right term, experts in the field that would deal with any complaints that are a standard of care?
So I'm going to apologize in advance. I don't have an answer to that, Ms. Mize. I don't actually work in this program specifically, but I can get the answer to that question from our department and get that over to you at a later time.
Okay.
I-
Is there any way for us to know how many of these complaints had an element of a standard of care issue within the complaint?
And that as well, I can get that answer to you as well at a later time. And again, I apologize. I don't have the answers to that offhand.
Okay.
Catherine, we were just talking about this the other day. We have one OP SME on, and part of my pitch today and what we'll be talking about in the field is to, ask for, we do need more SMEs, because the more SMEs we have, the quicker we can process the complaints, and the faster people can feel at ease, since most complaints are spurious. So they can wind, they can get through that stack a lot faster because they're an orthotist or a prosthetist.
Okay. And Steve, just for clarification, can you tell us what SME stands for?
Subject matter expert, sorry.
Okay, thank you.
Join us today.
So do you know if we have any?
We do, we have one.
We have one. All right.
But that one is having to do everything. And so that's, we want more subject matter experts. I can give that spiel now. I'm next on the agenda, so.
Okay, all right. Any other questions from the advisory board for Liz? No? All right. Very good. Well, then we will just move on to you, Steve, Compliance Division. Steve will present.
Sure. Yes, let's discuss subject matter experts. So one of the things we have on our website is, which has totally been redone and we have been working on for a while, but you can just enter subject matter expert and it'll bring up a link to the web form, and a person interested, it takes like 3 minutes to fill that out. Then enforcement will screen that and get back to you with the relevant forms and a deeper background check and all of that. Subject matter experts are paid, not a lot, but you are paid for your time. And the more we have, the better.
So Steve, I have a clarifying question for the public, perhaps. If you're on the advisory board, can you be a subject matter expert?
Sure.
All right. Ideally,
somebody from GC says
ideally, from your perspective, how many would be helpful for this particular program for us to have?
I think 3 would be good. You just don't want it all on one person, because obviously we're not getting a lot of complaints, but we do get many, and you have that same person reviewing them. You need kind of a mixture of ideas and experiences and personnel.
Okay, so then to summarize that, we have one. Ideally, you would like to see three. So we are asking at least two people, maybe more to come forward and volunteer. Well, it's not really a volunteer. You said it was paid.
Mhm.
Position to offer this for our agency or for our department.
And you're protected under the various administrative rules and laws from any type of prosecution or backlash.
Okay.
Which others could go into great detail about. So, and other things in compliance, we've been working on the rules and been working with Stephen Leary and everybody else, and those rules are up for the advisory board to consider today, and that has to do with Senate Bill 490 relating to balance billing. We've also been working with enforcement, field inspections, and licensing, education, examination, and customer service. And what we generally do, answering questions, kind of being the ball bearings when they get stuck and don't have the time to go down rabbit hole. We do that for them. And then if you've just this week, our entire website has been redesigned, and it's got a whole new look. It's actually, and you can go to the top of the page, and you can, our website is now in at least 5 languages.
Oh, wow.
So that was pretty cool. I was playing with that today. In terms of outreach, we went to the TechSoft last summer, and that was great. Stuart Myrick and myself, I presented, and I look forward to doing that again this year. We manned a table, and we had lots of great feedback and helped a lot of people. And we continue to work on our Health Monitor newsletter, and that's going to come out soon. We have, the last one was in December, and we have a new one that we're working on right now, and that will detail one of the articles in there will be all about itemized billing. We'll also update our webpage and send out a blast related to the new rule as soon as that is passed, pending your approval. We need SMEs. Oh, and in terms of rule review, we did do rule review. That was, I was like, I know we did this, but Catherine said we didn't. And that was in October of 21. The board reviewed that. And there have been, little incremental rule changes. Remember, we've got the human trafficking credits, the jurisprudence credit. I think one of the big things in that rule review is we eliminated the technician registration because that was voluntary, and we had like 5. And so there's just really no point to charge people for something that is a voluntary registration. And we made it easier for, we eliminated any fee related to changing the safety manager at a facility or the practitioner in charge. So that can just be done instantly online. So there's no processing. And those are just a few highlights and of some recent rule changes. So things have been progressing a little bit, improvement, a little bit better each time. But that's all I have. And if you have any questions, I'm happy to answer them.
Thank you for the timeline clarification on 2021. I felt like that happened a lot earlier than that, but you're exactly right. So thank you. Any other questions from the board? We have a very quiet board today. All right, moving on to Field Inspections Division, and Juan.
Good morning, everyone. My name is Juan Munoz. I'm the Central Region Manager here for Field Inspections, and I will brief you this morning. The first page here, what we're looking at, represents the total number of inspections completed for fiscal year 2023 in total. Then it compares first quarter fiscal year 2023 with first quarter fiscal year 2024. Right now, we're projected to do about another 90 inspections between now and the end of the fiscal year. So we'll get some more done. A couple of things have happened since our last advisory board. I'm sorry, did you have any questions about our numbers here before I move on?
No?
Okay. So I'll move on here. In July 2022, the Field Inspections Division began utilizing the new system that allows the inspectors to track inspections electronically. We call this system the e-inspection system, which allows us to better serve licensees. We increase our efficiency, standardize the data we collect. And as of November of last year, all our programs are on this e-inspections program. So it's all a digital proof of inspection that we do on site with all our licensees, and they get an email and they respond. And we interact with them through that system. So it's a very new system for us. Also, in 2021, the Field Inspections Division began development of a risk-based inspection process for inspectable businesses in accordance with the TDLR sunset review and legislation passed during the 87th regular legislation session. The Field Inspections Division began conducting risk-based inspections in the Orthotics and Prosthetics program in fiscal year 2023, so just last year. So it's a very new process for us. One very important announcement is as of October of last year, October 16th, Field Inspections brought in a brand new director, Chris Rossi, who's replacing Eric Beverly from our previous director. So pending any of your questions, that concludes our report.
Well, I have one, Mark Kirchner. I was
Yes,
just to ask about this. So last year was in 23, we were about 108 inspections out of 258 facilities.
Yes, sir.
And you're on track to do another maybe 90 of this year. So we're still around that 40% mark of the licensed facilities in Texas. Is there anything to try to improve that, to increase that count?
Well, so again, we're on a risk-based. We can. The problem with doing the risk-based right now is that first of all, as we already identified, the program itself has very few issues as far as risk because I mean we have very few complaints and we find very few violations. So they're gonna, I would say maybe in about 2-year time span thereabouts. We don't have any specific dates, but within about a 2-year time frame, we're going to get to all of them. Like I said, we just kind of introduced this late last year, so we didn't get the whole entire year to focus through. But I think in about a 2-year time frame, we should be able to do full circle and get to everybody. And again, if there's violations that we find at some of these locations, we may visit them more often than that. I hope that answers your question.
So on risk base, so like the 2 cases that were highlighted in enforcement, they were both practicing without license in unlicensed facilities. So would that be risk based to like increase this number? Like they would be put back on for
Yes.
say
Yes,
24?
There would be in addition to, yes, sir.
Okay, thank you.
Yeah, and that'll just happen periodically when we recycle the list. We try to recycle the list about every. I think right now we're doing it every year, so we'll include all of those other additional establishments or facilities that we determined are risk. They have a higher risk level, and we'll add them to that list as well.
Thank you.
Yes, sir.
Any other questions from our advisory board? All right, hearing none. Thank you, Mark. We will move on to the executive office, and Brandy Myers is going to present.
Yes, ma'am. Good morning, presiding officer and board members. My name is Brandy Myers. I'm the Deputy Executive Director over our Administrative Services area of the agency. Wanted to give you a personnel update. Since the last time you met, there's been a lot of changes in our agency. Mike Arizmendez, who was the prior Executive Director, had resigned and moved on to some other stuff in his life. And so Christina Kaiser, which y'all will recognize from she was our Senior Deputy Executive Director. She had stepped in and she was our interim and acting Executive Director, but she retired at the end of December. So we are excited for her and congratulate her on her retirement. And then a familiar name and face, Brian Francis, that you know, he's back. And so he is now our interim executive director. He started in January, so we've got about 6 months with him. And Steve Bruno, you'll recognize that name. He was our legislative director for the agency. He's now our deputy executive director over our licensing services. So that includes That includes our licensing division, our exams and education division, and also our customer service division. And again, I'm Brandy Myers. I'm new to my role as the Deputy Executive Director, but I'm not new to the agency. I've been here for about 5 years, and prior to this role, I served as the Chief Financial Officer for TDLR. So excited to be in a new role and excited to serve with you as we move forward. As far as the bill implementation update is concerned, the only thing that impacted your industry primarily from the legislative session was Senate Bill 490 regarding itemized billing, but I do not want to take Mr. Leary's thunder away, so I'm going to go ahead and turn it over with your permission, Presiding Officer, if there are no questions for me.
Any questions for Brandy? All right, hearing none, let's roll on to the discussion of new language surrounding Senate Bill 490.
Thank you, Ms. Mize. Stephen Leary, Assistant General Counsel. What I'd like to do, I'll give you all a brief overview of Senate Bill 490 and what these rules are trying to do. And then I'll share up on your screen. You should also have in your materials probably a copy of the rules. I'll just kind of walk through what the proposed changes are. So item G consists of proposed rules that were developed as part of our bill implementation process. The bill implementation team, multiple bills get assigned to each team, and we have personnel from the various divisions on each team. So I was on it along with a number of other people from the Office of General Counsel, Steve Ecker, Katie Bryce. A number of us kind of collaborated and worked on this. Senate Bill 490 from the 88th regular legislative session was dedicated to the topic of itemized billing in the healthcare industry. And as it was originally introduced, it applied to providers across the board and required providers to provide itemized bills. And the bill underwent some changes during the legislative process, and the final enrolled version of the bill, it only applies to facilities that are licensed, accredited by a government agency. So it changed the definition of providers and it narrowed it to facilities. And as a result of that, here at TDLR, it looks like the Orthotics and Prosthetics program is really the only one that's affected because here at TDLR, we accredit OPS facilities. The bill requires a facility to do three things. So within 30 days after the date the facility receives final payment on the service or supply from a third party, they have to send out, the facility has to send out an itemized bill, and it has to have a plain language description of each distinct healthcare service or supply. It has to have the billing codes for reimbursement that are being submitted to the insurance company. And
Stephen, I think Mr. Mojica had a question.
Okay, go ahead.
I'm sorry, Stephen. This is Miguel Mojica. Are you supposed to be sharing your screen, or are we supposed to be looking at this?
No, sir. I was going to do that next. I want just to kind of overview it first, and I'm going to walk you. I'll share it in a moment. I can share it now if you like, but I was just going to wait on that till I kind of get out there what this is trying to do before I show it. Is that all right? Okay. I'll get to. I'll get to that.
We're good.
Okay, sure. So there's three things you have to do that it requires. Okay, you have to send out the itemized bill. It has to be specific. It has to have the billing codes on it. And if the provider is alleging that there's an amount due for the patient, it has to say the amount that's due for each individual service and supply. So in other words, it has to be itemized. Okay. And it does this by creating a new chapter in the Texas Health and Safety Code, Chapter 185. And in Chapter 185, there's a section 185.003, which states that every appropriate licensing authority has to treat a provider's failure to comply with that chapter as a violation of the licensing statute. So as a result of that, these requirements are already in effect. The statute says that all the licensing agencies have to treat a failure of the provider to comply with Chapter 185 as a violation of the licensing statute. And so the intent of these rules was to make it clear in rule that we're implementing that new Chapter 185, and that facilities, OPS facilities, have to comply with the Health and Safety Code 185. I'm going to go ahead and share it up on the screen now and walk you through the changes. Now, as part of this implementation process, we also recommended some cleanup changes to the rule just to make everything fit and to make the rule fit with the format of other rules. I apologize. Looking for the right. Okay. I apologize. I'm having a little difficulty sharing my screen. We'll do that now. I think I'm having just a little bit of trouble with the. Okay.
Yeah, it looks like you're sharing your whole window, so you might want to
Okay. I don't
maximize
want
it.
to do that. Don't want to do that. Okay. Can you see the rules now?
There you go. Thank you.
Oh, okay. Very good. Very good. I apologize. For some reason. Okay. Okay. Very good. So 114.1, it used to say authority, and it had this language about the authority of these rules, the legal basis for this chapter of the rules. We decided to change that to authority and applicability, and that's mostly because other rule chapters do that, and just to make it consistent. And we're adding in the reference to the Health and Safety Code, Chapter 185, which is the new chapter that was enacted. On 114.70, excuse me, 114.7, I apologize. I'm having a little bit difficulty scrolling with this. You just bear with me. So it has responsibilities of licensees, and we added into the heading and accredited facilities. The reason we did that, the reason why I proposed doing that, is because that rule already talks also about accredited facilities. So we wanted to change that heading to make it fit what the rule already does. And the substantive change was adding in this subparagraph E, itemized billing. And that's saying that a facility must provide itemized billing in accordance with Health and Safety Code, Chapter 185. And it notes that failure to do so is a ground for enforcement action under Chapters 51, which is our general statute, and Chapter 605, which is the Orthotists and Prosthetists Act. Lastly, in Chapter 114.9, these are going to be fairly non-substantive changes. We added a heading for enforcement actions. We took out this bit here about authority because that's redundant of chapter of 114.1, which talks about authority. So we are recommending that. Just to sort of add some organization to that rule. It's a fairly long rule. We're adding in this heading fraud, misrepresentation, or concealment in subsection B, which is what that subsection talks about. Making some changes, non-substantive changes, adding in other applicable statute instead of provision, just to make it flow better. Going through it, that's about it. So the main part that we're recommending changing, the substantive change, is going to be in 114.70, where we're adding the subsection E. And that's the part that really implements Senate Bill 490. The rest of these were cleanup changes that were also recommended by the bill implementation team. I recommend that the board, recommend those rules for publication, but after we talk about them and make any changes today. And I'm happy to answer any questions, so feel free to ask questions.
Any questions from anyone on the advisory board? All right, I have one.
Sure.
So on the itemized statement, and it does, I see, refer to chapter 185, is there any clearer language that we can provide at the level of our chapter 114 to describe what that itemized billing should look like? And
Well,
I,
we could do that. I think the idea was we don't want to have to change the rule every time that statute was changed. So I think we decided to take a more global approach of saying, because they're already subject to that statute, of saying to follow that statute. The statute, I can also share up the statutes on the screen if you'd like. It's a very short statute, and it basically just has those three things. The plain language description of the service, the reimbursement codes, and the amount that the patient owes for each item. We could put that in the rule if that's the preference. I think we just thought that we wanted to keep it broad, so to prevent having to change the rule in the future. But that's just a preference thing. We certainly could do that. As far as anything else more specific, I mean, that would be up to you. We didn't, and that wasn't really recommended. But
so
sure, what?
Okay, so what you just said, let me repeat it and make sure that I heard it correctly. In chapter 185, it states that I, as a facility, would have to produce an itemized bill that stated the code, a plain worded description of that code or descriptor of the item, and a amount billed and an amount due, if there is due, from the patient on that same itemized level. Is that correct?
That is correct. And let me share it up on the screen just so everyone can kind of follow along. I think that's a good idea. It's a very, very, very short chapter, and so it doesn't give us a whole lot of doesn't give us a whole lot more than that. Okay, so I'm sharing it on the screen, and you can see 185, the new Health and Safety Code chapter. It just only has these three sections. Section 185001, which is the definitions, and you see a healthcare provider. At the last minute, they changed that to mean a facility. Previously, it was going to apply to all providers, but now it only applies to facility. The substantive part is this right here, is 185.002, which you'll see Part B, itemized bill must include, and it has these three things: the plain language description, the reimbursement, or the billing codes, and the amount that's due for each service or supply. Now, it does have in here that you can issue the bill electronically or through the patient portal, so that is okay. So it has that. It has the patient's entitled to this bill at any time after it's originally sent out, and that you can't send it to a debt collector unless you comply with that section. So that is in there as well. And the part that I think requires the rulemaking is this 185.003. It says the appropriate licensing authority shall take disciplinary action against provider for violation, as if you had violated the licensing law. Yeah, that's a good thing for us to look at and consider. And if you have any follow-up questions, I'm happy to address.
Brandy Myers, Deputy Executive Director. I would also like to add in that there is information about itemized billing on our webpage, and it won't necessarily be succinct in the rules. So I would like to guide our members over to the website for some additional information. Thank you.
Okay. I guess what I would like us to contemplate is when the rules are somewhat difficult to track and find, they're hard to comply with as speaking as a professional. So if, and this is perhaps not correct, But as an O&P professional, we tend to hopefully go to Chapter 114 because that's our set of rules for our guidance. And this, if I read it closely, would then push me to 185, which I understand Chapter 185. We and I have not looked at the website, Brandy, so I am falling short in that. But I just want to make sure that there is good direction to our professionals to understand what they're being asked to do and how to do it, so that they don't get caught short. And digging through levels of statute to find those answers is a challenge for most of us.
Absolutely. I totally understand your concern. I can say that just yesterday, as we celebrated our 115th birthday at CDLR, our website had been updated. And so I can tell you that our web team has done a great job to make our website much more user-friendly. So I'm hoping that that would help that navigation for you to find what you need on our website as well. And we can try to find some of that and send that your way if needed.
Yeah, Catherine, we're going to be updating as this moves through. We'll be updating the plain language, so you're not having. I mean, the links to the different citations will be to the different laws will be there, but something that's a plain language explanation of interpretation of the bill, so you can follow it.
Okay. Steve, would that be found in our FAQs on the page, or do I just need to stop here and go look at the new page and layout, and will it be obvious to me?
We need to. I have the page just went live, so I am not sure exactly where it is.
Okay.
Yeah, it would probably be under the practice standard. Yes, that would be a good place. Yeah, right there.
Okay. And will there be a blast out to all facilities and practitioners that there has been a rule change and that they need to pay attention, et cetera?
All OPS will receive notification of that this is required. You know, it comes down on the facility, but a building and can't do it. So it's the individuals. So we have that. We have that entire email list, and we can hit everybody who's licensed in the field.
Okay.
Stephen, Mark Hertzner, is there a way to clarify this maybe in our rules to make it very transparent for all
Sure.
licensees?
I think, sure, and I think there's sort of a tension in rulemaking in general between, on the one hand, we don't want to recite the statute verbatim in the rule, and on the other hand, so I think one extreme would be just to put 1, 2, and 3 here in a rule, and I don't really have a problem doing that. I think, as a general rule, we don't want to necessarily always put the whole statute in the for a number of reasons. One reason is just to shorten the rule chapter, to keep it from getting too long if it's a long statute. And the other thing is we want the rule to be broad enough to encompass if there were a change. But I don't think it would be a problem to do that. You know, I think we could do that today. We could just, you know, what we have right now in the rule, the failure to comply with 180.50, Chapter 185 is a ground for disciplinary action. We could possibly say failure to comply with 1, 2, and 3. You know, there's a number of ways we could do it. I don't know that we need to. And so I think that's a matter of preference. There's something to be said for not rehashing the statute in the rule and keeping the rule short. But then I understand what you're saying, that, you know, the licensees will tend to go to your specific chapter. But that's stylistic, you know, and I don't think it would necessarily cause a problem. Steve Lucker, I'm seeing a look on your face that you have comments.
Well, yes, I do. So the confusion comes with most of the industry does itemize descriptions, L codes, pricing for third party. The one thing that's probably not on those delivery receipts is what is applied to the patient. So I can see where we're going to have some licensees think that they're within the rule, but they're not doing it 100%.
Mhm.
And so I think clarification, in my opinion, I think it would help us relieve some of those questions, because I just can see this might be a problem.
Okay.
And once the rule is adopted, that's when the website will be updated. So we're not going to post these rules until the rules become law.
Thank you, Steve. Mark, one comment on your comment that you just made, and Mr. Leary, maybe you can correct me if I am incorrect. Mark, I believe you were referring to the proof of delivery that is itemized. That
Correct. Correct.
that
So most of our proof of deliveries are going to have L codes, they're going to have descriptions, and they're going to have third-party billing and what patient responsibility is. But not everybody does the patient responsibility side. So I think it would be missed, and people are going to think they're going to be in compliance, and then it's going to come back later because they're going to think that they're doing it correctly.
Right. So the other thing that I heard and that I made note of is that this statement, this itemized bill, goes to the patient within 30 days after receiving payment. So this would not be proof of delivery. This is something that happens after the fact. And so this is an example at this exchange right here of confusion of our proof of delivery versus an itemized bill that's 30 days after we receive payment, which could be 90 days after the service.
Well, ma'am, just to clarify, the itemized bill has to be sent out not later than 30 days after the provider receives payment. So you can send it earlier. You don't necessarily have to wait the 30 days. It's that by the time 30 days have elapsed from the time you got payment, you have to send out that itemized bill. And, you know, this statute is mostly directed at hospitals. It was designed to prevent surprise billing from hospitals. And, you know, it sort of incidentally also applies to us. But, you know, just to clarify, the 30-day deadline is the maximum, 30 days after you receive payment.
Okay.
So I think that would be a problem, because sometimes we don't get paid within 30 days. Sometimes it's 45 or 60 days.
No, our itemized notice to the patient must occur within 30 days of us receiving payment. So
Okay. Okay.
it could be 6 months later if it takes us that long to get paid. But it's not the proof of delivery. So
Am I misunderstanding, but this could be set out prior to the final payment being arrived, correct? They just need an itemized bill. Am I understanding that? So if I did a delivery and sent them an itemized bill 2 days after the delivery, that's still compliance, right?
that's not what I heard.
Well, the intent of this is, you know, it's been processed through the insurance. Insurance has paid what it's going to pay, and we're turning around and sending a bill to the patient. And it's really aimed at the problem of just sending a patient a bill that just sort of says you owe this amount. And so if it's going through insurance, it's supposed to say how much the insurance paid, what were the codes that were submitted to the insurance, what's left over, and what are you having to pay for each of these items. I think that's the intent. Steve Ecker, can you help me with this?
This is, I'm sorry to interrupt, but this is after we have received the EOB.
Right, that's the intent. The intent is after you've received the payment from the third party, which would be the insurance. So after the insurance has paid what they're going to pay, and now you're trying to balance bill, you're trying to turn around and say, hey, insurance didn't cover all this, you owe me this money. That's where the consumer has this right to this itemized statement.
So Catherine, let's say you're in the office, you've received your new orthotic or prosthetic device. I'm there, I'm covered under Blue Cross Blue Shield. So you know what the insurance would cover based on the codes you're going to assign, because is that a good statement?
Yeah,
And then
we,
it would
we,
be-
we have an expectation,
Mhm.
and many companies will give the patient an estimate of coverage at that point, but it is not guaranteed. So yes, we know what we've delivered, we know what the L codes are and the descriptors, and we have an expectation of what Blue Cross is going to pay us. A proof of delivery is given to the patient, and this is per federal statute. And that proof of delivery simply states that we have given you this device with this L code, with this descriptor, and the patient has signed it and said, I have received this device, this L code with this descriptor. They are not required to have any financial information on that form, but some people, as Mark Kirchner pointed out, do provide the expected estimate of payment on that. So what this new rule is then saying is that after we receive that EOB from Blue Cross with their payment, then within 30 days, we're required to send out the itemized statement telling the patient it's paid in full, you owe your 20%, whatever the remaining balance is. And so point being is that you can see how much confusion just this has created in conversation. And I am very nervous about the confusion that will be created across our professional CPOs across the state of Texas if we don't have some more detail in this section of 114.
Right.
So perhaps simply restating those 3 points out of chapter 185 is, I think, probably sufficient, then followed with education that Steve was talking about on the website and going to our shows, etc.
Right, because the patient goes, pays their standard copay for this type of visit, and then just like any other service, and then that may cover it, that may be great, or you get billed. And so it's just that explanation of what you're being billed for. That's when that would come into play, as opposed to new leg, or whatever.
Ms. Meisler, just to jump off of that, looking at the language we've drafted here, where it has itemized billing, a facility must provide itemized billing in accordance with chapter 185. I think we could expand on that and say, in accordance with 185.002, a facility must provide, just sort of rehash what's in there. That within 30 days of receiving payment, you must provide an itemized bill, which must include, and just those three. I wouldn't be opposed to doing that. I think there's something, there's sort of a tendency to not want to restate the statute, but if you think that's going to provide clarity, I don't see any legal reason not to do
Any, I like that thought. Any other comments from our advisory board members in agreement or disagreement or other ideas?
This is Miguel Mojica. Yes, I think that would clarify things. The other component that I'm seeing that may be problematic is the fact that it seems we're breaking everything down, and then also we have to provide a percentage of what each item, what each, the amount that the patient has to pay for each item. Usually, I think if I've looked at, and I do look at a lot of the bills here, it's kind of grouped together. This is what it is, and this is the percentage you're going to pay. But it almost seems like we want to break it down further to say, we added a padding in your AFO, and this is the amount that the insurance paid, and you're going to pay X amount for that item. Is that's what they're asking for? That's how much detail they're asking for. I think that's going to be an issue too, or we have to clarify that, like you're saying, Catherine. It needs to be pretty straightforward. You just can't group them all together and say here are all the items, and this is overall what you're going to pay. It seems like it's broken down per item. I think that needs to be probably brought up one way or the other.
Mark Kirchner, I agree with Miguel. Some of the things that we're starting to see in private now is some of these insurance companies are not separating this out. They're bundling it saying, this is what we're paying. And you can have 4 or 5 L codes in there and they will not break them down for you. And they're starting to do their own fee schedule. So I see a lot of confusion with this. So if there's a way to clarify it, I think it would benefit the licensees.
Thank you, Mark. Thank you, Mike. Anybody else on the advisory board?
Yeah, Randy Duncan here. Um, maybe some increased specificity would be helpful, but a lot of times going less specific and then handling the specifics in a FAQ, I think has been helpful. So that may be something to consider as well.
Okay. Other comments? All right, I need some help on how to direct from here. Within the confines of this meeting.
Of course. So you can ask for a motion to either publish the proposed rules on the Texas Register. You can ask for edits to the proposed rules. It's really up to you. Well, it's really up to the board what y'all would like to do, what y'all would like to propose.
All right. So I will propose a motion then. Is that correct? Okay. So I would like to propose a motion that we edit the language that has been proposed to us today to include the 3 elements of the itemized billing as is stated in chapter 185, clearly within the 114 chapter.
Mark Kirchner, I'll second that.
Okay. Do you want it to be on the Texas Register with those edits, or do you want us to go back, make those edits, and give it back to the advisory board?
Are you asking me? Yes?
Mm-hmm.
Yes.
Yes. Clarifying your motion.
Clarifying my motion. Yes, if the language mimics, as Mr. Leary outlined, if the language mimics 185, I think it could go, in my opinion, it could go straight to the public notice.
Okay. Stephen, is that okay?
Well, I just want to clarify on the record, as far as what the motion was and what the vote was. If the motion was to make those changes and to approve the rule for publication with those changes, then I want to clarify that the board authorized the vote. People who voted for the motion.
Right. We have not voted for the motion. So,
okay.
Yeah.
We just got to the second, right? And then we got.
Yes.
Okay.
So to clarify the
That's
motion.
what was second. That's what was moved.
Yes. So to clarify the motion that Ms. Mize put forward is to publish the proposed rules with the edits to include the 3 elements from Chapter 185 on the Texas Register for public comment. And then Mr. Kirchner seconded that.
Correct.
Okay, so let me go ahead and do a roll call vote for everybody. Miguel Mojica.
Yes, I'm good.
David Arends.
Aye.
Randall Duncan.
Aye.
Mark Kirchner.
Aye.
Eric Olson.
Aye.
And presiding officer Catherine Mize.
Aye.
The motion passes.
All right, so then I hope I'm not out of line here. So for clarification, with that passage of that motion, those 3 elements will be included in this language. It will then go to the public registry for publication. And our next meeting will deal with the comments that come in on that and go from there.
Yes, ma'am. That is the plan. And yes, so we'll need to set another board meeting at least 30 days from the date this goes out. So it'll be in a while. It takes time to get it published. It won't take me long to make that change. It'll take a while to get published in the register. The governor's office already, they didn't have any questions about this. And so this is a non-substantive change. I don't think it has to go back to the governor. So yeah, we'll make that change and then we'll go ahead and publish in the register and get the comment going. And then we'll hold a second advisory board meeting to consider the comment.
All right. Thank you very much. Any other questions or comments for clarification from anyone? Hearing none. Then are we, Stephen, are we finished with this section? Is there anything else that you need to deal with?
I don't have anything else on section on item G. I do want to note for the record, one of the board members, Mr. Olson, reached out by email wanting to have an item discussed, and I did not get around to getting that on the agenda for today, but it's possibly an item that's going to need to go to a work group for discussion. So I anticipate that'll come up later when we get into as a discussion for our next meeting. So I just want to throw that out there and acknowledge that we got that.
All right. Well, then I think we're concluding item G on our agenda, and then would move on to H, which is recommendations for agenda items for the next board meeting. So to your point, Stephen, is it appropriate here for you to bring up Eric's email and let's discuss if it needs a work group?
Sure, and he can explain it better than I can, but I understand he has some concerns about the academic requirements for licensed prosthetists or orthotist assistants. It feels that he expressed that the requirements, education requirements, were unduly limiting for what they were doing, and he wanted to take a hard look at those requirements going forward.
Eric, would you like to expand on that?
Sure. So as everybody knows, it's becoming, there's more and more patients and less practitioners in general. And the move towards using assistants is going to increase. If you look at the number of applications for certified practitioners this year, it was upwards, as she shared earlier. But for the assistants, it's 5 this last year. Those numbers are very, very small. The problem that I've run into on all of the people that I have worked with that are extremely talented, caring, compassionate people that would be exceptionally good assistants is college level math. I, for the life of me, can't understand the need for an assistant to have hours in physics unless they were developing products and being able to do formulas. One of the big issues we've had with the couple people that I am trying to get through this path is that every college and university in the state of Texas requires prerequisites of algebra, trig, and calculus to be able to get into a physics course. So,
if I may interrupt, I want to be sure that we don't get into deliberation of this item when it's not.
oh, okay, that's fine.
I want to give you the opportunity to bring up what the topic is.
So
it can be decided if it goes to a work group. We can't really engage in a discussion of why you.
Oh, that's fine. I understand.
So I apologize for that. And I apologize it's not on the agenda.
I'd like to eliminate only the physics as a requirement to become an assistant. The anatomy, physiology, all of those are strongly based, and we just want to get rid of the physics. And I want to discuss that because it's limiting applicants across universally. If you take college level math, you're probably going to become a full-fledged practitioner and get a full BA. If you struggle in college, probably not going to take college level math.
Okay.
That's the of it.
So for clarification, Eric, you would like the requirements to become a certified assistant in the state of Texas to be re-examined. You are, and that's the only licensee that you're asking for us to re-examine the rules around. You're not asking about the LPO, LO, or LP.
No.
Only the assistant. Okay.
Yes, ma'am.
All right. And so I think a work group would be appropriate for this. procedurally speaking, how do we decide whether this should go to a work group?
Well, is there a standing work group already in existence you wish to assign it to? You can do that. Or is there a new work group that you would like to appoint?
So we do have a standard of care work group right now. Catherine Mize, Randall Duncan, and David Arenz is currently on that standard of care work group. We can add Mr. Olson since he is the one bringing this up. Adding a fourth member we won't have any quorum issues if we do that. But that's up to Ms. Mize. She's the one that appoints all of our work group members.
This is Randy. Correct me if I'm wrong. I think there's examination and
Yes, we have an education and examination work group as well. Mr.
so I wonder
Mojica.
if that would be more appropriate to fit in that work group.
Okay. Mr. Mojica, Randall Duncan, and Mark Kirchner is currently on that one.
Yeah, this is Miguel Mojica. I think that would be the group that would address this.
So Ms. Mize, if you'd like, you can appoint Mr. Olson if he volunteers for that work group, and we can assign that to the work group.
Mr. Olson, do you volunteer for this work group, which I think would be a stellar idea?
Oh, love volunteering for work groups.
Excellent. All right. Then I agree that this is an appropriate topic for that work group. And I would like to add Eric Olson to that work group. And normally the way this works, or at least it's worked in the past, is there who would reach out from TDLR to these people on this work group to schedule the discussion?
It would either be me or somebody from our education and examination division.
Okay. And can we anticipate that this work group will meet as many times as is needed to have something ready for discussion at our next board meeting?
I'm sorry, I'm just writing our Deputy Executive Director, Brandy. She let me know that my math is wrong. We have only 7 members on this board, so 4 would constitute a quorum.
Quorum. All right. So if we add Eric too, we need to pull someone else off.
That's correct. So right now it's Mr. Mojica, Mr. Duncan, and Mr. Kirchner.
All right.
Now you can leave it as is, or you can remove somebody and add Mr. Olson.
Okay. The 3 people named that are currently on the work group, would any of you desire to step aside? And if not, we will leave it in your all's capable hands.
I'll let Eric step in.
All right, Mark, thank you.
He wants to talk about it.
Thank you, Mark.
You bet.
All right, so we'll remove Mark Kirchner's name from this work group, at least for this topic, and we'll add Eric Olson. And
Sounds good. I'll send everybody an updated list of the work groups.
Okay.
Will that action need a motion?
No, sir.
Nope. Okay.
So we also have proposed rules, and I went ahead and put work group assignments on here as well for the next board meeting, just in case you want to change it up a little bit. Did y'all have anything else y'all would like to talk about at the next board meeting?
Any other thoughts or ideas from anyone that needs discussion? And just for clarification, again, I like to clarify, don't I? If somebody came up with a brilliant idea of something that needed to be discussed at the next board meeting, what is the proper method for them to bring up that topic, and who do they contact, and what timeline?
They can shoot me an email, give me a call, send me a text, whatever they need to do to get a hold of me. We do file the agendas 8 days before the meeting, but we like to have it at least a couple of weeks in advance so staff can review it.
Okay, so if anybody thinks of something approximately 2 weeks before our next meeting, you can contact Anna for having it added to the agenda. Okay, thank you. Any other questions or comments? Moving on to item I, discussions of the date, time, and location of the next board meeting, which in my understanding will be somewhat driven on when these rules get published in the public record.
Yes, ma'am, that's correct. So after it gets published on the Texas Register, we'll be sending it back to y'all, and we'll be I'll be polling y'all for the next meeting.
All right, can we anticipate that that will occur in 2024?
I hope so. It should be within the next couple of months.
Okay. Thank you.
Yes, ma'am.
Then, without any other comments or questions, I believe I can call for adjournment. Any other comments or questions before I do that? Hearing none, then I will adjourn this meeting at, according to my computer, 11:37 a.m. I thank everyone for their hard work and attendance.
Thank
And
you all
we'll
so much. Appreciate it.